Guess they stepped away.
No, you know what? I muted the room.
Oh, you muted
Because
it.
they were having a
Oh, they
conversation.
couldn't hear us.
Nope.
Jay, Wilder, or Karen, would you like to comment on this draft? Or Commissioner Sherling, I see you're there, Tucker Jones. We have time for some brief comments, whoever would like to kind of go first. Wilder, go ahead. Or Commissioner Sherling, why don't you go first, if you'd like.
I will. Thank you, Senator. For the record, Mike Sherling, Commissioner of Public Safety. I will hand the baton to Wilda and Tucker in just a moment. But very briefly, as you might imagine, we remain opposed. This version, we do appreciate the committee's work to try to get to something that's more tenable, but this version is, we find it quite rushed, trying to assess it and do some kind of analysis in a matter of mere minutes. Most importantly, our underlying objections remain. This serves to single out law enforcement, to remove legal protections afforded to all public employees. That sends an incredibly bad message. It is an indictment of law enforcement. It is demoralizing in a way that is difficult to even convey, and without good substance in this instance. It'll be headline generating, and that will create collateral damage in the way of impacting our already impaired ability to staff, recruit, and retain. That situation is, it is not an understatement to say that situation is dire, and every policy decision or everything we telegraph that further erodes support for folks doing difficult work each day is damaging. And I just cannot understate that. So for the legal assessment, I'll turn it over to Wilda and Tucker, who are far more eloquent than I am.
Wilda, Tucker.
Yes, Wilda White, policy and training consultant for the Department of Public Safety. Again, I want to thank the committee for continuing its work on this bill and trying to strike a balance. I see a couple of legal issues with the bill that I would like to talk to about briefly. The bill states that it's the intent to codify ZULO, but actually doesn't codify ZULO. I mean, you haven't, stated what the test is, what people have to prove to actually bring a ZULO cause of action. And you've also created a inconsistency with ZULO in the words that you have put on the page. ZULO authorizes lawsuits against law enforcement employers. If you look at paragraph 30 of that case, it talks very favorably about the right person to sue is the employer, because they are in the position to change behavior through training and hiring. And it's because the lawsuit was brought against the employer that the ZULO court created this new test of qualified immunity, because employers before ZULO did not have the benefit of qualified immunity. That defense only went with the employee. But because the court approved of suing employers, it wanted to give the employer the same defense that its employee would have. And that's why it expanded qualified immunity to apply to an employer and shifted the burden as something that the plaintiff must prove. But here, you've set out a structure where you've authorized a lawsuit against an employee, employee, and then you're trying to deprive that employee of qualified immunity, which is something that the ZULO court didn't do. So I'll rest there. And the other issue is that just this description of ZULO as a damages limiting principle, that is not anywhere found in the case. I'm not sure what you're referring to, but ZULO does not limit damages. And I think those two things would be really confusing both to the bar and the judiciary, because they conflict with ZULO. And I'll give my colleague Tucker Jones an opportunity also.
Okay. Good morning, Mr. Chair. My name is Tucker Jones. I'm Assistant General Counsel in the Department of Public Safety. And thank you for the opportunity to address the committee again on this draft. We have been reviewing it just this morning. And I'm just going to focus my comments on page 1. So section 5607 and subsection A and B. I am also concerned about the meaning of 5607, along with Wilda's point that Zulo was a claim against an employer, not an individual. This draft proposes to eliminate qualified immunity as a defense in subsection B, but it advances the Zulo case, which not just embraced the principles of qualified immunity, but incorporated the qualified immunity legal standard into the elements of the cause of action it created. So the question arises now of whether a violation of clearly established law under the Zulo cause of action, as modified by this draft, is supposed to mean anything other than clearly established law as defined by our qualified immunity case law. So it is puzzling to abolish the doctrine in subsection B, while at the same time endorsing the case that embraced the doctrine and put the doctrine's legal standard into the elements of the claim itself. And this question remains, notwithstanding the fact that the doctrine is typically pled as a defense, and Zulo incorporates the doctrine into the elements of the cause of action itself. And this question also remains, notwithstanding the fact that there is an alternative disjunctive prong of bad faith in the element of the cause of action itself. So this is just a foundational concern with the way 5607 is constructed, kind of independent of the policy considerations surrounding, this debate we've been having this session regarding this legal doctrine. And so I will just leave it there for now, as just limited to this legal issue with 5607 specifically.
Thank you.
Thank you.
Jay or Karen? Jay, go ahead.
Hi, thank you, committee. This is Jay Diaz from the ACLU of Vermont. I just want to note that while we are, of course, disappointed that qualified immunity is not on the table to be eliminated right now, it is a defense that needs to be eliminated. I will say that the current draft does send a message. And that message is that the committee is interested in the needs of communities across the state that have lost trust in policing, that have lost trust in the justice system, and that have been denied access to justice too long. I think it's important that this issue at least be looked at, and that Zulo be seen as the law of the land. That's what this bill does. So we appreciate the committee's efforts here, at least to find some way to ensure that communities out there know that they're being heard, and that the legislature is interested in getting to the bottom of this issue. As to the substance of the bill, I'll be quick. I think the courts know what Zulo means. I think it's very clear based on the decision. It introduced a limiting principle on damages remedies. It's very clear from what the court said that, and in the language here, it makes clear that that's what the intent of the legislature is, to apply that standard forward to all police officers. However, I do agree with Wilda White's testimony regarding the confusion in talking about actions against law enforcement officers specifically, because this bill doesn't actually create a private right of action any longer. And so actions are only available against the state, county, or municipal entities. And so I've sent senators here, sent you some proposed language to that very simple change, I think, to make that clear and to cure this confusion. I also provided that to Ledge Council.
Okay.
The last thing I'll say is that I think this Part B of 5607 makes a lot of sense in concert with the other changes that I've discussed. The last thing I'll say is the section about a report on settlements. The last sentence there, removing transparency from the names of people who are involved in judgments. We have some concerns about that in terms of just public accountability and government transparency. We suggest removing that last sentence there. Currently, settlements with government entities would, I believe, by and large, unless subject to a different exemption of the Public Records Act, would be publicly available documents. Otherwise, we would appreciate the committee working toward on this bill, moving it forward, ensuring that we get some kind of report from Ledge Council on what the state of the law is, so that we can hopefully move forward this issue, and it'll be clear that the legislature does need to act here. I'm happy to answer questions, but thank you for this.
I apologize, Jay. I came in late. And why did you say we should remove the personally identified information?
My understanding is that currently that information in court judgments, of course, but also in settlements, would be publicly accessible. And so this would be an additional exemption kind of that you would be adding to the Public Records Act. Also, we have some constitutional concerns as it relates to judgments of the court having to be redacted for personally identifiable information. And then similarly for settlements where you're talking about government entities settling cases and having, whether it's damages or other remedies included in them, having those not be fully accessible to the public so the public can know what the government is doing.
Not
But
the intent
this
it's
doesn't
not the
say.
intent here to make this for all cases. It's only in terms of this record that would be accessible to the legislative council and others.
Okay, I think it was unclear to me from that might be my misunderstanding. It was unclear to me based on the language, but if that's the understanding.
Only the intent to try to get information. You know, we've heard from both sides that one side says there's a huge problem, the other side says there's not a problem because people already have access. And this would be just kind of for the purposes of this record. So I did not intend to make it the new law in terms of public records.
Let me just ask Jay a quick question.
Yeah.
Jay, you heard Wilda and Tucker talking about the conflict between subsections A and B in 5607 on page 1. Did you have any comment about whether you perceive any conflict there?
No, I don't perceive a conflict. If there is, because right now qualified immunity. Well, if we are applying Zullo to state, municipal, and county entities, which is the intent of this bill, for the actions of a law enforcement officer that violate Article 11, Part B, there is no conflict because qualified immunity, because that's basically what Zullo says, that qualified immunity can't be imputed from the officer to the state entity. And what this bill would be doing is extending that to municipal and county entities, or or certified law enforcement, for the actions of certified law enforcement.
I had understood the argument that Zulu applied to employers. This is now shifting the conversation to the employee. And I understand their argument to be a conflict between the two provisions. If you're adopting the Zulo standard, which covered employers, this now brings in the employee. Are those two phrases in conflict with each other? I had understood that to be their argument.
Joe, couldn't it be
So,
additive rather than, in other words, couldn't this be adding the employees to Zulu?
It is, and that is creating a new language I'm looking for. It is creating a private right of action against the employee as opposed to the employer.
Right, I just don't see it as a contradiction. I see it as,
Well, it says the intent is to codify the damages limiting principle established in Zulo. And the argument, as I understood it from Tucker and Wilda, was that you are now moving beyond that to actually create a cause of action against the employee.
So
I just,
say any action against a law enforcement agency.
You could if you were looking at line 18, but this is now damages against the law enforcement officer. If I understood their testimony correctly, Zulo is limited to the employer.
Right, that's what I'm saying.
This is now creating a new right of action against the employee. And so I understand where you're going, Jeanette. Yes, you could do that, but that's not what this says.
No, that's what I'm.
All I want to do is codify Zulo to make sure it covers all law enforcement agencies.
So on line
If
15.
that's what Zulo did, then we should be consistent.
It was, yeah, it was just against it was against the state, but against the agency.
So in this case, it would be the town of Bennington, or
Right, it would apply to all law enforcement
if the
agencies.
constable worked, it was a certified law enforcement officer, and worked for the town of Westfield, then it would be the town of Westfield, not the constable.
Correct.
So if you put law enforcement agency, it covers all certified, anybody who has a certified officer is a law enforcement agency.
Yeah, and what I had done in the
Yeah.
version that I'm currently editing is just add the definition, the cross-reference to 20 VSA section 2351A, which defines law enforcement agency as an employer. That should cover, that objective.
So that,
Sorry, I missed that.
that would be a change. Does that address, I'm not suggesting Wilder addresses your concern about the bill, but it addresses concern about the expansion of Zulo.
I'm having a hard time hearing. Senator Sears, were you asking me a question?
Yes, does the change to, instead of law enforcement officer, to law enforcement agency, I said, or recognize it doesn't address your concerns about the overall bill that were expressed by the commissioner. But does that address your concerns about expanding Zulo beyond what the decision was?
Yes, if paragraph A is limited to law enforcement agencies, the employer, that is consistent with Zulo and addresses my concern. B, however, if you left B as it is, it's kind of nonsensical because it would never be a defense because you wouldn't be suing the law enforcement officer.
Well, we'd be striking B.
Okay, so yes,
Agency.
yes. If you fix A by limiting it exactly to what Zulo said, which is the employer, and eliminated B, then I believe you have Zulo.
Yeah, and just with Senator Ruth, your question, qualified immunity is something that would only be available to the individual, not to the agency. So
I see.
it wouldn't be necessary in that sense. And then just to address the way it was phrased as a damages limiting principle, in section 54 of the Zulo case, there's a discussion about the purpose that qualified immunity has, one of which being a damages limiting principle. And then it goes on in section 55 to talk about that a plaintiff seeking damages. And then this was a way to limit the access to damages, to consider all of the, or to make sure to balance all the considerations facing law enforcement officers. So there is a discussion of a damages limiting principle that I think is in concert with the holding of Zullo and is sensible for clarity here. And also, again, when it's added to that it's a burden a plaintiff must prove to obtain damages, I think it's sort of a belt and suspenders approach to just make it clear that this is a limitation on damages, which I think was the bulk of the discussion in the Zullo case. So I just, that's the explanation as to why it was phrased and drafted that way. And then, but to Will's points about if you just make it against law enforcement agencies, that would be more consistent and you wouldn't need subsection B.
If we, on page 2, line 8, to strike the last sentence, well, first of all, personally identifiable information connected to a judgment or settlement shall be redacted prior to disclosure. So that was Jay's suggestion, just to strike that.
We could do that as well, and then it would just be subject to the exemptions under the Public Records Act.
Doesn't affect them. All right, anything else? Karen, did you want to comment?
Thank you, Senator. Yeah, I do have a couple of comments. Karen Horn with the Vermont League of Cities and Towns. We are concerned, as the commissioner mentioned, that this legislation continues to single out law enforcement officers on the issue of qualified immunity versus all other public officials who enjoy that that protection. We're also concerned about writing what could be some significant changes in pretty short time frame that always tends to lead to unintended consequences. It does seem to us that if you were going to conduct a study of the doctrine and the issue altogether, that you would include in that study what is the appropriate way to handle or extend the Zullo case. And then the one other comment that I need to make is that we would be very concerned if the section 5608 record of case disposition were adopted without the language all personally identifiable information would be redacted. The Public Records Act applies to governmental entities, does not apply to individuals, is my understanding. So we think that also might be something that a study would refine, I guess is the best word. Thank you.
Thank you. Yeah.
So Karen, what you're saying is that if we took that line out, then all information about both the person that is being, any judgment, all that information would be public. So everybody would know who got the settlement, who the settlement was against. Is that what you're saying, that we shouldn't be disclosing that level of information?
I think that would be the case, and we think that is not something that really should be in the records of all final judgments and settlements. That's maintained by a law enforcement agency. I'm not an attorney. I can't delve too far into the details of that, but if the purpose is to find out how many such judgments there are, we don't believe that you really need to have the personally identifiable information as part of that. And the way it's written, if that's taken out right now, it would affect everyone, as you indicate, Senator White.
Okay. Thank you all. Anybody else? Brad Myers.
Just for the purpose of saying it, we got a text from Vince asking that if section B, page 1 is not removed, they'd like an opportunity to testify.
It should not
Just so
be
you know.
removed.
All right, Brad, go ahead. Briefly, please.
Muted.
You're muted, Brad.
Okay, can you hear me?
Yeah.
Okay, first, thank you, Mr. Chairman, members of the committee. I agree with everything that Mr. Diaz has said. I emailed each of you on Monday, but based on this morning's discussion, there are 2 points I want to raise. First, with what counsel for the League of, or excuse me, with what Ms. Horn said. I just read an article yesterday about how in most police misconduct lawsuits, the millions and millions of dollars that are paid out by municipalities, most of those payouts are based upon the actions of repeat officers who are repeat offenders. I think that if you follow what Ms. Horn is saying, you're depriving the public of very important information that would target, that would be beneficial and would identify officers who are literally repeat offenders. I think anytime you remove, basically you provide a secrecy covenant in any kind of settlement of civil litigation, it is a profound disservice to the public. So I would ask that subsection C not be modified and that there be full disclosure to the public of officers who are the subject of any settlement. Chiefly, I'm concerned about the notice of claim. With due respect to legislative counsel, I haven't researched this. I don't know if there are any Vermont cases or statutes that involve notices of claim. They're common in New York and other states. My concern is that it unduly burdens plaintiffs, particularly if the plaintiff has not yet retained counsel within 1 year. That what you're basically doing with, I think it's 5609, you're imposing a 1 year statute of limitations. There is no need for a notice of claim. There has not been one in tort cases, even against municipalities, I believe, although I could be mistaken, in Vermont. Sometimes, particularly with regard to psychological injuries or traumatic brain injuries, the full extent of the harm is not known.
Where are you? There is
I'm
no,
wondering, I think you have an old version.
there is no section 5609.
The draft of February 25th.
No, you're
No.
way off.
March 11th.
Okay, I apologize. I did not see that. All right, then,
In the interest of time, Brad,
yes.
I really appreciate your effort. I've got 5 minutes left to either kill the
Proceed.
bill or vote on it.
All right,
So
thank you for giving me the chance to speak. I will.
no problem. And I appreciate your comments. Senator, Commissioner Sherling. Final
Thank you.
comment.
Just very briefly, point of clarification regarding the accessibility of public records relative to settlements. Again, this is on the fly, so I haven't done a robust analysis, but all the cases I've been involved in where there have been settlements, those are public records, including the names of the public employees involved in those settlements. So, do what you will with the end of the bill as drafted, but that information is currently public. It would be our position under the existing public record statute, as it should be.
I'm going to ask Senator White asked the Government Operations Committee to look at this section
Oh,
between now and the time if we get a vote, positive vote. Just briefly. Just ask, never mind.
I,
Be there.
Okay, so it's, and that is,
okay. Do you want to?
all right, so what we've got is, making clear that Zulo is about the agency, not the law enforcement officer, so it strikes the reference that both Wilder and Tucker brought to our attention. And it also strikes lines, the last sentence of section 5608. Okay. Is that clear to everybody what the new version would be, 4.1?
It would say law enforcement agencies, and I would strike B.
The only question is, does the damage limiting need in there? If we just said
Could say the principle.
intent of General Assembly to codify
The principles, yeah.
the principle established by the Vermont Supreme Court, Zulu v. State, blah, blah, blah.
That sounds good.
Take out the damage limiting. So it would read, it's the intent of the General Assembly to codify the principle established by the Vermont Supreme Court, Zulu v. State, 219 BT, 1, as a burden that plaintiff must prove to obtain damages in an action brought against any Vermont state, county, or municipal law enforcement agency.
What it was sort of.
Oh, any certified law, no.
No, any law enforcement.
Yeah, what it
Oh,
would,
right, any, it's not Vermont state, any law,
Any law
any
enforcement.
Vermont law enforcement agency.
Yes, certified. No, it's the officers, this is law enforcement agency, which includes places like the Secretary of State and DLC. It's anybody who hires a certified officer is a.
So read.
Yeah.
It is the intent of the General Assembly to codify the principle established by Vermont Supreme Court and Zulu v. State, 2019 BT1, as a burden that the plaintiff must prove to obtain damages in any action brought against any Vermont law enforcement agency for a violation of Article 11 of the Constitution of the State of Vermont.
And I think you were gonna cross-reference, I think it's Title 20.
yeah, I'm gonna add another subsection, just cross, saying that the law enforcement agency has the same name as.
The next question is on section 5608. Do we strike all personal on line 8, the last sentence?
If it's already there, according to the commissioner.
Yeah. All right, that's the bill.
So we will be leaving, lines 8 through 10 on page 2.
Seems it's already public record, according to Commissioner Sherrill.
Well, but this says it should be, was his testimony that it's now available but not redacted? Because we're saying here that it should be available but redacted.
I don't know, what did he say? Commissioner, are you still there?
Well, just to, if I may speak on that point a little bit, I know that there was discussion talked about the Public Records Act and how it plays out. It would be a request that you make upon an agency, but you could request anything that's within the agency's purview, so individual records, whatever, judgments. But some of the exemptions are records that by law are designated confidential, ones that may interfere with enforcement proceedings or to be reasonably expected to disclose the identity of a confidential source, things like that. So
Not anymore.
the Public Records Act may already protect against inadvertent disclosure. It was really, I think, a drafting attempt to be a belt and suspenders approach.
So,
So I think you can take it out.
yeah, if we strike that, we'll just have the
Yeah.
existing.
Yeah, it's the existing and personally identified is usually redacted from any public record.
Okay. Is there a motion to report favorably? Senator Baruch has moved, we report the bill, or amend the bill and report it favorably. Excuse me, amend the bill, amend the S-254 as seen in draft 4.1.
Still four?
Any further discussion? Peggy, would you please call the roll?
Senator Benning,
No, and I feel like I should make an explanation, but I don't think we have time.
Go ahead.
I am concerned that we're doing this, the last minute, applaud you for taking steps to try to make this work. One of the things I really like about it is you're calling the collection of data where we don't really have. But I'm very nervous about this sort of proceeding, and I know it's gonna come back to us, and we'll be having the same conversation in 5 weeks. And the body is done with it, so I would have hoped for something much different than we're passing.
Good, Senator. Peggy?
Yep. Senator Nika? No. Senator White? Yes. Senator Baruch?
Yes.
Senator Sears?
Yes. Motion to report the bill favorably as
Was that?
Senator Baruch says.
That was the amendment. That's the only vote we're taking?
no, we're taking now a vote on.
The bill.
Okay, that's what I thought. Okay. Ready to take it?
Yeah.
Senator Benning?
No,
Senator Nika? No. Senator White? Yes. Senator Baruch?
Yes.
Senator Sears?
Yes.
I do not.
So. Thank you all.
Thank you.
Right,
Thank you.
Go to the reporter.
I guess it falls to me. Did you want to report it?
No.